across the entire country. Erin would have been assigned to thousands of those cases, and then as now, many, if not most of those cases involved unrepresented petitioners. Consequently, she is certainly well familiar with the needs and experiences of self-represented litigants. As her career progressed, she was designated industry counsel for the banking and financial industry in what was then the IRS Industry Specialization Program. Her interpersonal skills allowed for successful team building with appeals officers and revenue agents, and I can speak from experience that getting chief counsel attorneys, appeals officers, and revenue agents to work together to agree and resolve difficult tax issues is not always easy. And that ability will certainly serve Erin well in her new role. Erin was able to do so, and with her problem-solving skills, she created solutions that allowed for an across-the-board resolution from all those functions of the many tax problems that arose from the collapse of the savings and loan organizations. Later in her career with Chief Counsel's office, Erin was appointed as special trial attorney, and as such, she received prestigious national and regional awards for the manner in which she handled some of the largest and most complex tax court cases. Erin left a successful career with the Office of Chief Counsel for what turned out to be an equally successful career with KPMG. There, she handled both domestic and international tax issues for high-profile and, when it suited their interest, clients who preferred to keep a low profile, and her exposure to tax issues that typically affect unrepresented, unsophisticated individual taxpayers, up to and including those issues that face the well-armed and sometimes overly represented corporate taxpayers, certainly makes her well-suited to the important position she is about to assume as an advocate for all categories of taxpayers. And after all, to point out that she wrote the book on federal tax practice would not be a cliche. Erin, along with her husband, Ed Robbins, also known to many of us, authored an IRS practice and procedure desk book that I refer to regularly and expect that many of the participants in this teleconference do as well. On a personal level, when Nina also retired, I'm sure that many shared my concern that her successor would never be able to match Nina's competency, dedication, persistence, and passion for the position and the causes she advanced. I won't go so far as to say that within a few months of Erin taking office, we'll all be asking Nina who, but I'm certain that Erin will make the transition seamlessly. And like Nina, Erin's powers of persuasion, subtle, but not so subtle when necessary, are simply remarkable. As is obvious from the need and the purposes of this teleconference during this difficult period, the needs of the low-income taxpayers have increased and are increasingly by geometric proportions, a phrase we've heard all too frequently recently. That being so, the responses and relief offered by the folks involved in this teleconference must be as robust, and I expect that Erin will be charged with picking up that relief where the relief contemplated here ends. Quite frankly, I can't think of a worse set of circumstances for Erin to begin her new career, but I'm confident that given her compassion for others that I've witnessed over our many years of friendship, her competency and her past experiences as a tax professional, that she is more than up to the task. And Erin, you should take some comfort in knowing that as a result of Nina's efforts, you are going to inherit a TAS organization and a network of LITCs that will no doubt significantly reduce the number of sleepless nights you would otherwise be in for. So enough said. Erin, it is honestly one of the high points of my career and a great honor to welcome you to the world of LITCs and their clients, where every tax issue has a human face. So good luck.
I have to say that I believe that Erin had been connected to the call and got disconnected. So what I'd like to do is turn the program over now to Jennifer Breen and Sheri Dillon. Jennifer is a partner with Morgan Lewis and Bockius, and she's also vice chair of this committee, the Pro Bono and Tax Clinics Committee. And Sheri's a partner with Morgan Lewis and Bockius as well. And she's also vice chair for Pro Bono and Outreach with the tax section. So let's turn it over to them, and what we'll do is we'll circle back to Erin when she gets back in. Thank you.
Thanks, Susan. Hi, this is Jennifer Breen, and I'm going to kick us off with respect to the legislative activity that we're going to first talk about. And I'm going to take a moment just to describe where we are as of this afternoon legislatively. So congressional relief thus far has been referred to as phase 1, phase 2, and phase 3. And so I'm just going to quickly touch on what each of these phases mean, and we hope to kind of bring into focus the issues that are really relevant to this community. And so with respect to phase 1, that was HR 6074, the Coronavirus Preparedness and Response Supplemental Appropriations Act of 2020. And this was an $8.3 billion emergency funding bill for coronavirus vaccine research and development. And this legislation was overwhelmingly supported by the House and Senate. They passed this legislation on March 5th, and the president signed the bill into law on March 6th. After that, they went back to pass phase 2. And phase 2 was HR 6201. And that's the Families First Coronavirus Response Act. Folks may have heard this just referred to as Family First, and this was the first piece of legislation that really had some tax implications. This was passed, it passed the House on March 14th, with technical corrections passed on March 16th. And it went over to the Senate on March 18th and was passed there and signed by the president that same day. This package, phase 2, included legislation that created a leave mandate and an associated employer credit. So what it did is it established a federal emergency paid leave benefit program. And this was for employers with fewer than 500 employees, and they were required to provide 2 weeks of sick leave if employees were unable to work because they were either subject to quarantine or isolation, or because they were experiencing symptoms of COVID-19, or they were caring for someone who was in quarantine, or they had children who were in schools that were closed. And basically that pretty much includes almost every person here in the United States. It complements the Family Medical Leave Act, and it provides an additional 10 weeks of pay at a reduced rate for paid family leave for child care. It does, and I won't get into the mechanics of it, but it does provide employers with tax credit to offset the cost of paying this leave, and it's something that I know the IRS has been working on. I'm going to come back to that in just a moment. But also relevant to this community is it did provide other benefits, such as free testing for COVID-19 and aid for nutrition assistance to provide meals for those who did not have food security or who do not have food security. So the IRS quickly acted after this was passed, and on March 20th, they came out with IRS announcement IR 2020-57. And this was Treasury, the IRS, and the Labor Department's announcement on how this plan to implement the Families First Act was going to roll out. What the IRS provided is that they will be making prompt payment for the cost of providing the leave. And this announcement provides that guidance is going to be released in the near future. And while this is not necessarily something that our clinicians are necessarily focused on, many of our clients may be receiving this leave benefit. And so their employers, they may have questions about it, about whether or not or how it's going to be paid. Guidance is going to be released in the near future that will permit eligible employers who pay that qualifying sick or child care leave to retain an amount of payroll taxes equal to the amount of the qualifying sick or child care leave that they've paid, rather than deposit it with the IRS. And the IRS has said that they're going to be issuing guidance for employers on how to implement this credit. The Labor Department also recently issued FAQs as well on this, and I think we should all just stay tuned to the IRS for more information regarding how this will work. And then I'm going to turn to phase 3, and this is we're a little still up in the air on the finality of phase 3, but I think we're very close to being to having a phase 3 complete, at least in the Senate. Phase 3 is considered, folks refer to phase 3 as the Coronavirus Aid, Relief, and Economic Security Act, or the CARES Act. It's currently been pending in the Senate. We've had various versions of this legislation that's been going back and forth, subject to ongoing negotiations, but they did announce that very early this morning around 2 a.m. they were able to reach an agreement. There's increasing optimism that this will be passed in the Senate later today, and from there it's going to go over to the House. Once phase 3 is passed, Congress will move on to phase 4. And I think for those of you who might be interested in what that might look like, you might take a look at the House bill that was introduced by Pelosi earlier this week for an idea of what phase 4 might contain. We're going to focus just on the key provisions that are relevant to individuals, especially those that are the clientele of this organization. And most importantly, it provides stimulus payments. It established a refundable credit paid in cash for 2020 of $1,200 for individuals that have an AGI of $75,000 or less. That number is increased to $112,500 or less for those filing head of households, and a $2,400 credit for married couples filing jointly with an AGI of $150,000 or less. In addition, there's an additional $500 for each qualifying child, and there's a phase out for taxpayers with income over those threshold amounts that I mentioned a second ago. There's also a waiver of the 10% early withdrawal penalty for distributions of up to $100,000 from retirement funds for affected individuals. So there's other provisions that are included in the CARES Act that has currently been pending in the Senate, but those are the two provisions that are really relevant for the individuals that would be seeking help through our clinician community. And so now I'm going to transition to Sheri, and she's going to just discuss the mechanisms of how these stimulus payments are going to be paid out. Sheri?
Thank you for that summary, Jenna, so far, and I'm going to try and address the mechanics of how these payments will be made. That the legislation contemplates that the IRS will principally administer the payments by looking to 2019 tax return filings. And in the event that no 2019 return has been filed, then they will look to 2018 returns for information. And the reason for this is the IRS is trying to look to, or the legislation is contemplating that the IRS would look to the last known address, and that might be the best place to find it, as well as correct direct deposit information. Reflecting again that everyone wants to use the most current data. So it is critically important that the IRS does have updated information. In the event that there are no such returns or the IRS isn't able to identify it, they can also look to the SSA forms, 1099, as a point of reference for where to send the stimulus check. The takeaway here is to get your 2019 returns filed, especially even though there are these extended deadlines. This is important so that the correct information is at the IRS and the stimulus payments can get to where they need to be. So that's a key takeaway. Importantly, the legislation also contemplates that the stimulus payments cannot be subject to offset for other federal taxes or liabilities. This is great for the stimulus payment, but we note that this doesn't address other refunds that might be subject or could be used for offset. And we know that's going to be addressed later on in today's program, either by Chief Counsel Desmond or Maria Smith. So we do recognize that that issue is also an important issue beyond the issue of the stimulus payments not being taken or snatched for offset. Also, the legislation contemplates that the Treasury and IRS will conduct a public awareness program, and ultimately, in the event that taxpayers have not received their stimulus payment, they will be given information on what actions the taxpayers should take, or if they're not taxpayers, our vulnerable population should take in the event that they don't receive a payment. Again, that sort of also raises the question and provides our answer for perhaps those folks who are non-filers because they're below the filing threshold, who don't otherwise receive SSA 1099s. So hopefully this information will also tell those folks who they should call. We recognize that there are issues being raised for the IRS and how to craft the rules. They are granted authority, regulatory authority under the proposed legislation, and we're hoping that they'll start thinking about things that we've been thinking about. I know many have raised on the Tax Connect postings are things for what about our joint filers who were joint in 2019 but now divorced? What happens when kids are split between households? What about foster kids? What if there's the death of a spouse? So all of those things we're hoping the IRS will be addressing in guidance as time goes on. Also, while not a tax provision issue, another note that we saw in the contemplated legislation is that they have increased and relaxed unemployment benefits. It looks like it's for up to 39 weeks without a waiting period and includes the self-employed. So that could also be some great information for our population that we're talking about here. Some other tax-related provisions, and again, the reason I'm raising these are while it may not directly be useful for our clientele, I think it might be useful, meaning the clientele, the ultimate population we're trying to serve. This may provide some opportunities for those of you in clinics and who are obviously have to do a fair amount of fundraising. Something that may assist you in your fundraising is that individuals, the charitable contribution limits have been increased up to a taxpayer's AGI, less other charitable contributions. And it also increases charitable contribution limits for corporations to 25% of AGI and increases the limit on contributions of food inventory from 15% to 25%. So again, while there's some of those indirect sort of provisions, or I guess indirect assistance provisions may also really help this population and help you all in your efforts to help the population. Couple other interesting things that, again, I don't think will affect you that much, but may free up corporations having more money and more money to provide to charity will be things, number of business types of provisions, notably things involving increasing Section 163J limits on business interest expense and other sorts of things. So hopefully corporations maybe and our other individual taxpayers might be in a position to better help and support the efforts that you all do every day. And again, once phase 3 is passed, as Jennifer said, Congress will move on to phase 4. And I think this might be a good time, Susan, for us to transition to Chief Counsel Desmond.
Hi, it's Mike Desmond. Good afternoon, everyone. Thank you, Sheri and Jen, and also Judge Carluzzo for the introduction to Aaron. Hopefully, Aaron can join us here momentarily, and if she does, please feel free, Susan, to interrupt me and have Aaron join us. So we're all definitely looking forward to having her come on board at the IRS and welcoming her to the headquarters building here in Washington. So I wanted to pick up where Jen and Sheri left off and just comment briefly on the phase 3 legislation, what's known as the CARES Act moving in the Senate. I guess most importantly is to note, as everyone knows, that that's not yet law. We are certainly anticipating that that will be passed and there will be a stimulus provision included in there. But already the IRS has gotten lots of phone calls and inquiries about where the stimulus payments are. And we are working very hard to implement that provision once it's passed into law. But just ask for a little patience to get the law enacted and the IRS to be given a little bit of time for implementation of the stimulus program that's anticipated as part of the Phase 3 CARES Act legislation. On that note, I'm sure everyone on this call knows, but just to remind folks, there is a lot of information available on irs.gov. There is a landing site there for the coronavirus tax relief page. And on that page are all of the guidance that we've issued so far to date on the Phase 2 legislation, the credits that Sheri mentioned and Jen mentioned, and also any additional news that we can put out about the stimulus payments will be put on that website that the IRS has posted there. So it's a good source of information. I do expect that we'll see some news very soon, perhaps even while we're on this call, about the final legislation that's being introduced in the Senate. I know that's been a work in progress for the last few days, and a lot of people from Treasury and all around the city working on that legislation. So certainly anticipating that coming through later this afternoon. So shifting gears a little bit from legislation to some other breaking news on the IRS front. Just minutes ago, the IRS released IR 2020-59. This is what we are referring to as the IRS People First initiative, and I think it addresses many of the concerns that folks on this call have with respects to underserved populations and the populations that a lot of the clinics serve. So this has, and I'll just sort of tick off, but it should be on the IRS's website. If not now, it's on the news release. I just saw a heading that was sent to me from the IRS's news release page. So it should be out there widely distributed very soon. But a couple of things that IR 2020-59 and the People First initiative address. Installment agreements that people have in place right now. For taxpayers that have an existing installment agreement and are worried about making payments on that, the IRS is suspending all payments due between April 1st and July 15th on existing installment agreements. So that should hopefully help provide a lot of relief for folks that do have in-place installment agreements. Also on offers in compromise, the IRS is taking a number of steps to address both pending offers in compromise and also payments that are being made under current offer in compromises. So pending, I think taxpayers are being given a little bit more time to get information in if they do have an OIC application that's pending. And they also have an option of suspending all payments on accepted offers in compromise until July 15th. So that's, again, relief that the IRS is providing with respect to offers in compromise. In addition, I know a concern under the current circumstances is delinquent tax returns and the consequences those can have for offers in compromise. The IRS will not be defaulting an offer in compromise for taxpayers who are delinquent right now, and will be given until July 15th under the filing and payment extension deadlines to get current. So there's no, at least short-term immediate urgency or concern about defaulting on an OIC if a taxpayer is not in a position, given the current circumstances, to get their return filed. In addition, the IRS is announcing that it will be suspending field revenue officer initiated liens and levies. So field collection activity will be suspended temporarily given the current circumstances. The IRS will also be suspending its new automatic systemic liens and levies. So in addition to the field collection activity, we'll be suspending the automated lien and levy program for a period of time. We'll also not be referring passport certifications to the State Department. That's also part of the current package. And we'll also not be referring new delinquent accounts to private debt collection agencies. So there are a number of other parts to this Taxpayer First initiative that the IRS has put out, so I'd encourage you to take a look for that once it's announced. It is out there. It just came out a few minutes ago, and hopefully this will provide some much needed relief to a number of taxpayers served by folks on this call in low-income communities. So that is out there, again, IR 2020-59. Shifting gears back to some of the issues that we've addressed over the last week or two. In particular, I know everyone saw the payment relief that was announced in Notice 2020-17 and the subsequent filing relief that was announced in Notice 2020-18. And just as a preliminary matter on this, and I think it probably resonates with everyone, but the circumstances we're under now under the current emergency are obviously unique. They're not necessarily the kind of relief or situation that was contemplated by what is typically given under Section 7508 Cap A in terms of deferrals of tax obligations and deadlines under the code. So the situation we're dealing with right now, I guess, is unique in a couple of ways. One, just in terms of the geographic scope. I don't know that we've ever had a national emergency that covers the entire country. And also in terms of the evolving nature of the current emergency. I think when the Notice 2020-17 was released, giving some payment relief for payments due on April 15th, that was just a couple of weeks ago, less than a couple of weeks ago, and the situation that we're in right now has certainly evolved and perhaps wasn't anticipated. So we've got both a very different geographic scope for the emergency and also a unique evolution in the emergency that we're dealing with right now that is not, I think, analogous to the typical hurricane or tornado or earthquake that we deal with under traditional 7508 Cap A. So that has presented a number of challenges for us as we try to respond to the evolving nature of the emergency. And I know there are a number of issues that have not been fully addressed. We've gotten a number of incoming requests for additional relief. Those are all being carefully tracked and considered. We put out some FAQs yesterday as to what the filing and payment relief extensions actually mean. And hopefully that provides some much needed clarification as to what Notice 2020-17 and Notice 2020-18 provide. But again, stay tuned for additional announcements about relief that could be given. We have received a number of requests and certainly recognize that there are other time-sensitive deadlines in the code, and including things relating to the tax court and petitions that we need to address and we'll try to address going forward. So I'll also just flag, although I think it's in part been subsumed by the Taxpayer People First initiative that the IRS put out, but there are a couple of other announcements that we've put out, the FAQs I just mentioned that went out yesterday. There's also a statement that the IRS put out about our mission critical functions and how those are continuing. We have not broadly extended statutes of limitations for the IRS or collections or assessment limitations periods. So the IRS is certainly focused on preserving statutes where necessary under the context of the People First initiative. Much of the initial assessment and collection activity is done not necessarily running up against a time deadline, so there's some more flexibility there. But in certain cases where there are deadlines that are running, the IRS will certainly have insight into that, and we'll be looking to work with taxpayers on that. That announcement that we put out yesterday on the mission critical operations also talks about other things that the IRS is doing, and in particular trying to focus on automated assistance through the website. It does note there, and also in a number of other places, obviously with the high call volume that's coming in given the circumstances, that's expected to increase significantly if Congress enacts or when Congress enacts the stimulus payments. So I would just encourage people to be patient, if at all possible, look for alternative channels of communication through the website in particular. And that's not only the IRS's general hotlines, but also the practitioner hotline, which is experiencing a significant increase in volume, and we expect that to continue. So just to ask for folks' patience on those approaches, but the IRS is trying to keep all those channels open. While at the same time, the IRS, like all other businesses in the country, is dealing with the exigencies of the current circumstances. So some issues there and some challenges there for us. I think the final thing to note is that with respect to counsel operations in particular, we are continuing to work. Unlike the shutdown that we had last year, all of our attorneys and our field attorneys in particular are working. The vast majority of them are teleworking, but they are available to work cases. If you have docketed cases, they should be available by email and by phone. We have had a number of conversations with the court where we, I think, are on the same page in trying to move cases to the extent possible during this period. As I said, we have people available to work those cases and who want to work those cases. We, I think, share the court's interest in trying to move cases where at all possible towards settlement, and appreciate the court reaching out to us and telling us they're available, as they always are, to facilitate settlement discussions. That can be done almost all the time over the phone, so this circumstance shouldn't discourage any of us from taking those opportunities. Also, the court has encouraged us, and we are certainly receptive to working cases that can't be settled, but working them towards stipulations and perhaps Rule 122 submissions so that a fully stipulated case can be submitted for resolution by the court. So other ways that we are working to ensure that work continues and that when we come out of these circumstances, we aren't faced with a huge backlog of work to do and get as much done as possible during this difficult time period. So with that, I know, I think the court is going to give us some insight on what they're dealing with, or Susan or anyone else, if there are questions on what I said, happy to drill down on some specifics. Otherwise, I can turn it over to the court for their thoughts.
This is Jennifer. Before we do, I think Sheri and I had a couple of things that we just wanted to highlight for you, Mike. I know that you're looking at it and considering it, and what you just sent out will make a lot of this probably irrelevant or hopefully irrelevant. But to the extent that there are things like signature relief that will permit electronic signatures for tax returns or other documents, has the service given any thought to that? And would we see anything in that area?
Yeah, thanks, Jim. We have received a number of comments and questions and inquiries along those lines. That is an ongoing topic. That was a topic of significant discussion before this situation came upon us. There's obviously some tension there in terms of authentication and concerns about fraud and other things in authenticating taxpayer signatures. So there is some flexibility the IRS has with respect to incoming documents and signature requirements in particular. And I think the current situation, as I said, there had been some ongoing discussions about ways that we can work on that and perhaps make for more liberalized standards. I know the Taxpayer First Act that was enacted last year does speak to that issue, and we were working on that project when the current circumstances hit us. So we have heard more recently, given the exigencies that we're facing, requests for some additional flexibility in signature requirements. And we are talking with the privacy group here and others about ways we might be able to accommodate that. So certainly very top of mind for us, and recognize the challenges that people have in getting to the clinics, in getting to VITA sites, and even getting to a facility where they could sign and mail and fax in the information that they normally do. So very top of mind for us.
Thank you for that. And Sheri, I don't know, are you still on mute or are you off of mute?
Yep, no, I'm off.
Okay.
And I do want to just express, I think, everyone's appreciation and I guess gratitude both to the IRS, Chief Counsel's side, Commissioner's side, as well as I'm sure the Taxpayer Advocate Service had a big role in getting this together so quickly. I think there's probably a big sigh of relief collectively across the practitioners who are listening to the call that a lot of our concerns were addressed, and thank you. And again, we do hope you look at signature relief. I know that's causing some issues as well. And we're also hoping, and I think, I'm not sure if you addressed this, but things with passport revocations, putting pauses on EITC freezes, other sorts of things that I'm sure we can see on the website. I did see that it is posted, so more detail is available to everyone there. So everyone, be sure to go to the website to see more detail or to see the things that Michael just quickly ran through. One last thing that I think we've been talking about, we do know that the IRS does have the authority to extend other deadlines that they have not yet extended, particularly things like on filing tax court petitions. Our understanding is both the courts and the IRS have been looking at this, and we'd certainly, Mike, I don't know if you have any views to share or if you would like us to ask the court to address this or where you all are on that.
Yeah, I'll turn it over to the Chief Judge and to Judge Carluzzo and Judge Panuthos. But we have had discussions with the court about that. There is some concern about that. I think with the People First initiative, and this might be a short to medium term response, that does obviously signal a ramp down of current enforcement activity. So I think in the short to medium term, that will result in a decline in inventory of statutory notices of deficiency and the need to file tax court petitions. I realize that doesn't solve the problem or address the issue for folks that have currently have 90-day periods running on stat notices and other documents that need to be petitioned or can be petitioned to the tax court. So we are thinking about that. As you said, Sheri, there is broad authority under 7508 Cap A to extend deadlines beyond just payment and filing, which has been done so far. And the tax court and those petition deadlines are at the top of our list on things to consider what to do with. And we have spoken to the court about that, understand and have a shared concern about ensuring that taxpayers are not forced into a situation where they don't have access to mail, don't have access to advisors, don't have access to clinics, and get put in a difficult situation there. So we're certainly very aware of that and hope to have something out soon addressing that.
Great. I think that would be very beneficial, especially for the taxpayers who are in this situation right now with the statutory notice. And in this time, between the challenging times of everything else they're dealing with. Plus, I think it is a little bit confusing, as we all saw, like during government shutdowns, while we do have Geralnik and some other jurisprudence out on this, it's confusing for especially the pro se taxpayers who are trying to navigate their way. So I'm hoping we can hear from the court with Chief Judge Foley and Judges Carluzzo and Panuthos on some of their thoughts on how all this will work out for this community.
All right, thank you. I hope you can all hear me. I want to thank you for the opportunity to update you all. You all know how important your role is, and during times like these, your commitment to service and excellence is particularly appreciated. The first thing I want to emphasize is that the court is open. Our courthouse is closed, but our judges are working and available. So as Chief Counsel Desmond mentioned, we have judges who are processing cases, who are taking conference calls, and who are willing to work with the parties to make sure that these cases are closed and as many cases as possible that can be resolved without a trial. They can be submitted via Rule 122. And let me just clarify the building status. Judicial officers and certain support staff are allowed access to the building, but most of our employees are teleworking. Private delivery services and mail will not be delivered to the court during this period, and we are waiting for the building to reopen before we start mail service again. And I emphasize that taxpayers may comply with the statutory deadlines for filing petitions or notice of appeal by filing a timely petition and mailing a timely petition to the court. Petitions and documents may not be hand delivered to the court, so it's very important that people recognize this, and it's very helpful for you guys to message that and get the word out. We certainly welcome the release of IRS guidance, IR 2020-59. I haven't had a chance to review it, but I'm hopeful that it resolves many of the questions that we, of course, have. I've been in contact with Chief Counsel Desmond about our concern with respect to certain deadlines, and we've also been in contact with the Hill to alert them to some of the issues that we have. So it's my hope that if things aren't resolved administratively, then perhaps they can be resolved legislatively. With respect to case processing, I want to point out several things. Petitions are not being filed or processed, and we also are not processing other paper filings. So note, however, that e-access and e-filing are up and running. I want to emphasize that the court encourages pro bono and low-income taxpayer clinic attorneys to assist self-represented petitioners to register for e-access. So please get this message out. Registration can be done via phone or email, and detailed instructions are on our court's website. Also be advised that paper service during this period is particularly difficult. And we have the majority of our staff is teleworking. We have a small group of folks who are coming to the building on a daily basis. but we're developing processes to handle paper service, and it may take longer than normal. Note, however, that our decision documents are being prioritized. Let me talk a little bit about trial sessions, because we've canceled quite a few of them. And it was necessary to do so for obvious health and safety concerns for the public. We, of course, are concerned about our litigants, practitioners, clinics, witnesses, and also our judges, and the small pool of trial clerks and traveling staff that goes along with them. All of you are familiar with what our calendar calls look like. It's a place where we oftentimes have numerous people, sometimes close to 100, and that is not the kind of gathering that we need to be doing during this time. So given the current issues, we decided that it wasn't prudent to proceed. Again, even though we're not having sessions, we're not having calendar calls, we are still processing cases. And we've talked to the IRS, and I welcome this opportunity to talk to you guys so that you all know that it's really important that you continue to work those cases, you continue to contact the IRS, and when necessary, contact the judges on the court to help you resolve these issues, close these cases, and put them in a posture where they can be resolved via stipulation if possible. When we canceled the trial sessions, the cases are assigned to the judge who is going to preside over that canceled trial session. They will retain jurisdiction over it. You all know that we're a court of nationwide jurisdiction. We travel all over the country. So we have to constantly monitor what's going on in a variety of different cities. So we're aware of the fact that there are some people who have travel restrictions, some people who are on lockdown. And we're also aware that this pandemic is having a different effect in different parts of the country. So all of those are things that we're monitoring and keeping a close eye on. Judges are trying to accommodate the parties during this difficult time. But I want you to, I can't say it enough, that you need to continue to work with the court, work with the IRS, and use this as a time to push these cases and resolve as many of them as possible. Finally, I just want to point out that we're going to continue to update you via our website. When appropriate, we will have press releases to inform you about what the court's working on and decisions that we've made. And we also recognize that there are a lot of restrictions on people. There are travel restrictions, there are stay-at-home orders, there are folks who are on self-quarantine, and we know that that's going to have an effect on filing things with the court. So our judges know about this. To the extent within the law we can be sensitive to those concerns, we are going to be. But again, there are certain restrictions that we have to follow that are pursuant to the law. And so any relief that can be provided legislatively or administratively, we would of course welcome. So in light of that, we're continuing to work with Congress and continuing to talk with the IRS about some of these issues. And we certainly will keep you updated with our operational status and other concerns. Thank you.
Hi, I'm Bridget Roberts. I'm the acting National Taxpayer Advocate for a few more days. Before I go into an update on what TAS is doing, I wanted to see if we were able to get Erin to join us.
Bridget?
No? Oh.
I'm unmuted.
Yes,
can you hear me now?
Okay. Yes, Erin, welcome.
Yay! I apologize, everyone, for the little technical difficulties, but that is life. It's probably the least of all of our challenges today. So good afternoon to everybody. Appreciate you joining. I had anticipated starting off by thanking Judge Carluzzo for his kind words, but unfortunately I have no idea what he said, so I'm going to hope that they were favorable.
It was blah, 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 good luck.
Blah, 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 good luck. Well, in today's environment, the luck will be much appreciated. So first of all, I am both honored and privileged to have been selected as a National Taxpayer Advocate, and I guess I'm joining in a very opportune time. Things are very quickly moving and changing, and I really look forward to working with our great TAS team and the IRS, and more importantly, all of you, the folks on the call today who are giving your time and efforts to work on behalf of the taxpayers. It is truly appreciated. You know, the TAS group, it has a unique role within tax administration by being the voice of the taxpayers within the IRS. But you all play a really important role in making sure that those in need are represented and treated fairly within the tax system. So your service is really important to tax administration. And I want to thank you in advance for all the work that you will be doing, because I think this is going to add some complexities. I think today's call was very appropriate and timely. As the Chief Counsel, Desmond, pointed out, you know, things are just being issued today. There's going to be a lot of changes. I suspect there's going to be a lot more guidance coming out in the near and probably long term with respect to how things are moving, both with the Taxpayer First Act as well as the COVID-19. I mean, we're all witnessing sort of how this pandemic is kind of turning all of our lives upside down. The lives of those around us, our families, our friends, our colleagues, is also impacting the economy and, more importantly for all of us, the U.S. taxpayers. So all the help that you give the taxpayers and you give the service and tax administration by getting that vital information out to the public is really key to trying to get through this crisis in the least painful manner that we can. So on behalf of the IRS, I want to thank all of you for what you do for taxpayers and tax administration, and echo a little bit what Chief Justice Foley was mentioning about the virus, trying all of us to be safe, you know, working flexi-place. But at the same time, I think we all acknowledge we have a job to do, and we're going to make the best of the situation. And as like Desmond pointed out, please be patient, because I think we're all going to be overextended for a period of time. But I think our goal is to get through this, and I'm confident that we can. So sorry for late joining of the call, but Susan, I'll turn it back to you.
Okay, thank you. And I would like to now turn it over to Bridget, Bridget Roberts, the Acting National Taxpayer Advocate, to talk about what's been going on with TAS, the initiatives that TAS has undertaken, and what we're looking forward to. Bridget?
Great. Thanks, Susan. And thanks, Erin. We're very, very excited that you will be starting on Monday, even in the midst of all of this. So I wanted to give everyone an update on sort of where TAS stands in the midst of all of this. We are very excited about the People First initiative that the IRS has just put out. And a big thank you to a lot of you on this phone who elevated issues and concerns and suggestions that we were able to give to the Commissioner and others that made their way into the People First initiative. So I think the IRS is really doing a great job of trying to address the unique circumstances that we find ourselves in today and trying to take very taxpayer favorable positions right now. So in the midst of everything that is going on, TAS is still fully open for business. We took some steps early last week to make all of our employees telework eligible, which is something that we haven't done before. So all of our employees, with a few exceptions, are working from home. Some who have never done that before, many working from home with children and family members that they are also taking care of. So to echo what Erin said, sort of please be patient with us. We are working as best we can, but it is unique circumstances for all of us. But we are still open to carry out our mission and to help taxpayers resolve their IRS problems. A few changes: because we are operating in a virtual environment, we have suspended all face-to-face walk-in services until further notice. At this point, we don't have our employees going into the office at all. We've directed that they all stay home, stay safe, and work from their houses. So we are doing all of our communication with taxpayers and representatives virtually. by telephone, by fax. We are still figuring out the mail, so that's an issue that we are struggling with as well as the IRS, particularly in offices where there are sort of shelter-in-place orders. Whether or not the mail is getting delivered and we can get it is an issue that we are struggling with. So we are trying to use phone and fax as best we can. We are using our local phone numbers for our offices to take in new cases. Unfortunately, because of the IRS's move to have everyone telework who is eligible and then sort of reduce staffing amongst those who go into the office to support social distancing, there aren't enough employees to answer the IRS's centralized intake line. So our 877 number that people would typically call to be routed to an intake advocate is not being answered at this time. Instead, you'll get a message, hopefully in the next few days, that advises you to go online, look up the phone number for your local office. So our local office lines are still working. You will either get someone who will answer or you can leave a message, and we are pulling all of those messages and calling people back. It's just that centralized intake line that is not open. We are putting up a web page to keep everybody up to date on any changes that are happening within TAS along the lines of sort of the phone line and other changes that might be forthcoming. We are taking a look at our inventory right now and trying to sort of triage what we have in-house and what's coming in to make sure that we are focusing on refund-related cases first to try to get money into the hands of taxpayers as quickly as possible. Pretty much all of what TAS does involves us sending an operations assistance request to the IRS, and there are certain parts of the IRS that are still trying to figure out whether they have the manpower to work those ORs. And so we're trying to really focus our work right now on the refund-related cases, particularly the wage verification cases. Something that did come out in the People First initiative today is that taxpayers will have until July 15th to respond to the IRS to verify that they qualify for EITC or to verify their income if their refund is being held for wage verification issues. So we are trying to focus on those cases to work with taxpayers to get the information that they need to provide to verify their income or to verify their eligibility for EITC. We are working with our employees to talk to taxpayers about being creative in the ways that they can gather the necessary documentation, particularly for EITC, where schools are closed and doctors' offices are not focused on providing medical records and things that we would typically ask for to substantiate an EITC claim. So we are trying to get creative and figure out other ways that we can substantiate those claims to try to get that money moving to taxpayers as quickly as possible. So we will really be focusing, for the most part, immediately on those wage verification, EITC cases. Taxpayers are currently unable to visit a TAC to verify their identity if they have a return that is being held under the Taxpayer Protection Program. So in these situations, the taxpayer can, if they're unable to do it over the phone with the IRS, they can contact TAS, and TAS can work with the taxpayer to get the necessary information and documentation from them, and then send that over to the IRS to try to assist them in verifying their identity. Some of our other cases that are typically systemic burden cases are ones that might have to go on the back burner temporarily while we try to focus on the refund cases. So if there is a case that you feel sort of needs immediate attention, we're really trying to, as we take these cases in, identify, is there a time-sensitive issue that we need to address right now, or can it wait, because there are certain parts of the IRS that are still trying to figure out sort of at what capacity they can work right now, and their ability to work impacts our ability to do our work. So it is sort of a downstream consequence. I will say one of the questions that we have been getting asked is about the CAF unit and the practitioner priority line. I think there's a note about this in the news release that went out today. But just to make it clear that both the CAF units and the PPS line are operational. However, they are both operating with reduced and very limited staffing right now. And they are not transshipping work, which means sending work from one location to another. So if you send your CAF inquiry or papers to one unit and there's no one there who's available to respond, that's going to stay there at that unit until there's staff available to respond. We don't have the ability right now to send that information back and forth between the two units. So the responses to faxes might be slow. The partitioner priority line remains open. It's one of the few that are still open, but again, there's very limited staffing available, so there might be long delays on those calls. Our clinics remain open for business. They are all looking at alternative ways to be able to serve taxpayers remotely, but they are making the adjustment as well. And we have started updating the LITC toolkit every day for grantees and their volunteers so they can get as updated information as we have about sort of what's going on and what we know from the IRS. So I think that's all I had, and then I think Maria was going to talk about offset bypass refunds.
I think before Maria discusses the offset bypass refunds, what we'd like to do is return to Sheri and Jen for an additional question to the tax court.
Sure, this is Sheri. I just had a question for Chief Judge Foley or whomever can answer it, but you were coming in a little bit on my phone. I was having some feedback and I didn't quite hear. I knew that you wanted us to continue to work our cases and to continue to work with IRS counsel, but you did indicate that if we needed judicial assistance, we should contact the court. And we just wanted to better understand, given the challenges and circumstances we're under, how would you like us to contact the court if we need our judge to be involved?
We've gotten rid of it. All right. Okay. I think I figured out why we were having that annoying echo, so I hope we've solved that problem. But the way that I'd like for you to contact the court is the way that you've typically contacted the court. Call them. So the calls may go to voicemail if no one's answering it, but all calls are being retrieved, and you can anticipate a return call in those instances where you need assistance. So I would encourage you to work with the IRS on these issues. Come up with a time that works for you and the IRS, and then contact the court to find out what's a good time for them to schedule a conference call. And there are instances where depending on the number of people who you want to have on the call, it might be more convenient for you guys to actually set the conference call up. And in other instances, the individual judge might want to perform that administrative task. But all of our judges are different, have different policies, but all of our judges are available and would welcome the call from you guys and the ask for assistance. So just all you have to do is call, and you may not get an immediate response, but you will get a response.
Very helpful. Thank you. We just wanted to make sure we understood what procedures to follow. We will hopefully be able to work with our colleagues on the other side so that we don't have to trouble the court for routine matters. But in the event where we need some help, it's good to know how to get it. Thank you, sir.
All right. I might also point out that there are also some, in addition to the regular trial sessions that have been canceled and suspended, there are also some special sessions that have been canceled, and those special sessions will be rescheduled for a later date. Of course, now is a very difficult time to try and schedule anything because you just don't know where things stand. But
we are aware that we're going to be very busy when things do return to normal, and we are anticipating that.
Thank you,
right.
Susan. That's all I had.
Okay, thank you, Sheri, and thank you, Judge Foley, for that clarification. One of the most important tools that TAS has and that the IRS can offer is this offset bypass refund. And I thought it would be helpful to ask an expert in the area of offset bypass refunds to talk with us. And so I'm turning the phone over now to Maria Smith, who's what's called an accounts technical advisor. Maria? Maria, I think we're having some trouble with Maria. I do apologize for the technical issues that we're experiencing. So what we'll do is we'll go back to Maria, and now I'll ask Julie DeVola if she could speak to us a little bit about what is going on with the ABA tax section, the initiatives that the section is undertaking, and the resources that might be available.
Yeah, so hi, this is Julie DeVola, and just wanted to let you know we're trying to coordinate some, resources of our own in response to this COVID-19 crisis. We're putting together a resource page that should go up today or tomorrow. Be kind as we go through some growing pains on it. But what we're just trying to do is bring together, links and resources that we think would be helpful, including, I'll just do a shout out to the AICPA, who, when I looked at this 4 days ago, was a 60-page document dealing with all the state and local deadline changes. And when I looked at it today, it's a 155-page document, so continuing to be updated. We're including, links to all the laws. We're going to try to put up, firm client alerts that explain them, general links to resources. Of course, the page that Mike mentioned, the IRS resource page is an awesome resource. We'll, obviously link to that and all those underlying documents. If people see things themselves that they think, would be a good resource for people to have, please forward it along to us so, we can include it. And we hope to start, offering free webinars and free forums like this to get the word out to the extent the IRS, Treasury, or the courts need a platform for communicating to folks. We hope that we can provide that service whenever there's a need. So that's all. Just to let you know that something will be going up. We'll be sending an email blast out and just trying to bring together as much information as we can.
All right. Well, thank you for that, Julie. Let's try once again to see if we can get Maria to participate in the call. Maria, can you say hello, and hopefully we'll hear you. Again, I apologize for the technology phone. Great. Yay, we have Maria. So, Maria, as I said earlier, offset bypass refunds are one of the most powerful tools that we can offer to taxpayers, and you're really an expert in this area, and I'm hoping that you could present some information for us now on how that works and things that practitioners should be aware of.
Right. I actually put together a little thing here as far as some key points. We know that the IRS does have a policy not to offset against outstanding federal debt liability if the taxpayer can demonstrate that they have a hardship. And in these cases, the hardship is within the meaning of IRC 6343. And the associated regulations, meaning the taxpayer needs to show they have an inability to pay their basic living expenses. So in this situation, with everything that's going on now, we know there's a lot of people out there that either are barred from working because shelter in place, work is shut down, things like that. So we're going to have unique situations for this, because it's not going to be the standard typical where they have an eviction notice or a foreclosure or utility shut off. These are very different times. So in the situation where we have the IRS is able to bypass that debt, they're referred to as offset bypass refunds and OBR. And unfortunately, there are strict time limits on when the IRS is permitted to issue an OBR. And so because they are so time sensitive, they must be acted upon immediately. So I'm going to run down a few points to keep in mind when servicing clients and in your population to have up front, because right now we have limited contact. A lot of face-to-face contact is barred or not safe, let's put it that way. And so when you do have that contact, you want to get as much information as you can from the people you're working with. Normally, standard, there's two issues associated with this type of case. The first is for the IRS to bypass the debt and issue a refund, and usually with Taxpayer Advocate Service, we want to address that debt with various collection options, things that will be available after when this is all over to avoid that potential IRS collection enforcement actions in the future. I'm just going to focus on the first part. So unfortunately, the IRS has no discretion to determine whether an offset to a past due child support or other federal agency non-tax debt under the Treasury Offset Program, or known as TOP, should occur. So if the taxpayer owes both a IRS federal debt and a TOP debt exists, then unfortunately the IRS has no authority to be able to issue an OBR in that situation. The IRS must first use the refund to pay the IRS debt, and then the remaining refund would go towards the top debt as well. Before issuing out an OBR refund, the IRS does contact the Bureau of Fiscal Service, known as BFS, to determine if a top liability exists. We do not rely just on information that's read through the computer system. We actually usually talk to a live person. So in that contact, we're checking to see if the primary taxpayer or even the secondary, if it's joint return, has such a liability. With everything going on, if the taxpayer has that top liability and any of the agencies have suspended collection of the debt, much like the IRS, then the agency will determine if the suspension includes offset of IRS refunds, and they'll notate the records to prevent that offset. That's something on the part of BFS doing that, not a decision made by the IRS. However, as mentioned earlier, these refund checks from the CARES Act package, that when that goes through and those checks do go out, they are not subject to offset to either another IRS debt or a top liability debt, meaning the child support or other non-tax debt. So an OBR requires to have the hardship and supporting documentation showing the amount of the refund needed to relieve the hardship. That's in a typical past case. The OBR would only be for the amount shown on the hardship documentation, and it would be a paper refund check mailed directly to the taxpayer. Any function in the IRS can issue an OBR. However, only TAS has the flexibility to accept verbal verification of the hardship for the taxpayer with unique situations, which is what we're going to be encountering now, where the documentation cannot be provided. And only TAS can issue a hardship refund as a direct deposit to a taxpayer's bank account. Now, that's going to be a crucial point right now in the situations we're facing because of the limitations of access to in-person banking services and things of that nature. So if at all possible, we'll want to be able to advocate for that direct deposit. Anything we can do to alleviate, people's nerves and stress levels, we want to do as much as we can. So if the documentation for the hardship cannot be provided, TAS employees may ask for some financial information just to document and to show an inability to pay those basic living expenses. They also may ask for authorization to contact a third party for verification. I'm sure there's going to be a lot of understanding going on, and try to not be rigid in asking for types of documentation and things. TAS, because of this, TAS does have the added flexibility of utilizing a signed local taxpayer advocate statement to advocate for the taxpayers with this unique set of facts and circumstances, but where there's a lacking in traditional documentation, or even dealing with the imminent date where time is of the essence. It's not always going to be a situation where you can get various documents and fax them into any place or things like that. So we'll work the best that we can to work around that. Fortunately, the IRS does require TAS to provide proof of the existence of the bank account for a direct deposit. And this is something mandated by GAO as well. So the acceptable proof must include the bank's routing number, account number, and if it's a checking or savings account. This could be a letter from a bank that contains the information and says that the taxpayer is the owner of an existing account. Or it could be a voided check. Unfortunately, bank deposit slips are not acceptable because they don't always contain the needed information. In addition, the bank account must be in the name of the taxpayer receiving the refund. And if it's a married filing joint return, then both spouses must be on the bank account. Accounting, has been mandated to protect possible fraud issues, that both taxpayers be on a joint account if it's a joint refund. There are some exceptions in the case of if one of the spouses is deceased, things like that. In addition, in the past, I had came up with refund anticipation loans, RALs, or refund anticipation checks, RACs. Those are agreements between the taxpayer and the tax preparer or software provider. It used to be interpreted incorrectly, but there is no legal basis requiring the IRS to honor RAL-RAC agreements. It's a matter of policy that the IRS had said that they would, honor those. So TAS has adopted a policy to honor these agreements, and we will always issue refunds directly to the RAL-RAC bank accounts whenever possible. So in the situation where a taxpayer files a tax return electronically and uses a tax preparer or even the software, typically in that situation, the refund will go through a RAL or a RAC account so that the provider can deduct their fee for the preparation from that refund, and then it's deposited or issued out directly from that account to the taxpayer. It's usually very transparent. If TAS cannot deposit the refund to the RAL or RAC account, they will notify the taxpayer that they will need to contact the tax preparer or software provider to arrange to pay any fees for the services because it will not be deducted from the IRS refund. They will, the taxpayer in that situation will receive the refund for the full amount directly from the IRS. So these are some key points. Each taxpayer situation may be different. There are items that may be requested. These are the items that may be requested. This will give you an opportunity to ask the individual for the information in advance, but do not delay contacting the IRS or Taxpayer Advocate Service to request an OBR. These are time sensitive, and the IRS has a very short period that an OBR can be issued from the time the return is filed. With daily and hourly changes, I recommend filing tax returns electronically and calling the IRS or Taxpayer Advocate Service no later than 1 business day. We can see these returns electronically coming in very quickly and be able to get a jump on being able to do the paperwork, the necessary paperwork to be able to bypass that debt, IRS debt, and issue that refund. Alternatively, you can call Taxpayer Advocate Service prior to filing the return, but be prepared to file the return when requested. That also gives an advance notice to work directly with a case advocate for that refund. In most situations, once the offset has occurred, the time permitted for the IRS to issue an OBR might have been expired. So it's extremely important in that context. If there are other conditions that are holding the refund, such as Bridget had mentioned as far as weight verification and things like that, then Taxpayer Advocate Service will work directly with the taxpayer yourself, you're representing them, to resolve those issues in conjunction with the OBR request. So Taxpayer Advocate Service, we always try to handle as much as we can to resolve everything all the way through. So the only thing I can stress is time. It's very important. And Susan, that's all I have, really.
All right.
Unless,
well, thank you, Maria.
Sheri or Jen has questions.
Yeah. All right. Well, Maria, thank you very much. That's really important information to help taxpayers who face an immediate need. And I'm glad you're able to share that with us. I want to thank the speakers for taking the time to talk with us today. I want to thank the audience for your patience as we dealt with the technology glitches. And I appreciate all the information that was shared and the time that you all invested in listening to us today. We really had a truly remarkable group of speakers. This, I hope, is going to be the first of several phone calls that the Pro Bono Tax Clinics Committee is going to have with regard to issues as they unfold during this time. I do know that we will host a conversation with Erin Collins, the incoming National Taxpayer Advocate, just to get a sense of her view of things, her perspective on the TAS mission, and where she sees us going, and taxpayers' issues as they're evolving under her tenure. So with that, I want to thank everybody. I also want to give a shout out to Meg Newman and DeMarcus Freeman for their patience in handling the technology problems that we encountered. So thank you, everybody. Stay safe, and we'll talk to you soon. Bye-bye now.